It's only on the left here.
Check. So till we are setting this up, are we done? Okay, great.
Am I
Yeah.
audible?
Yeah, you're audible.
Yeah, hi. I think the laptop is giving slight problems. They're just setting it up. So my name is Saakar Yadav. I am the founder of Lexlegis.ai. And while we're waiting for the laptop to start, just give you a brief introduction. I'm an ex-National Defense Academy dropout. Made India's largest repository of appeals. Started doing the work long ago, 1998. In the year 2000, had launched India's first tablet PC. It was called PC Slate. It was, I don't know, how many people here graduated after 2000? Can you raise your hands? Okay, and how many people graduated before 2000? So the rest of the people here are non-graduates, I understand. Okay. Okay, so making the case for legal AI with Lexlegis.ai. So Lexlegis basically stands for Lexicon on Legislations. So there's a large repository of legislations that we had built, and we are now using it to service the legal community. In India, there are about 44 million cases that are pending in various courts. Now, when I say courts, it includes, there are over maybe 1,200 courts in India. So these are the tribunals, these are the district courts, the High Court, and the Supreme Court. Last year, there were 13.5 million, 1.35 crore cases filed, amounting to over 60,000 cases every working day. This is managed by over 15 lakh or 1.5 million advocates and millions of paralegal people who are assisting them throughout the country. They are conducting over 11 million searches on various relational databases, the old databases, and the Googles or the Bings of the world. This is a high-level statement. Indian laws are very complex. In fact, I like to tell you that the Income Tax Act has the maximum changes or amendments to any act in the world. And both citizens and lawyers are in constant search for answers to the issues. See, why I'm saying this is nobody is looking for a judgment, please mind it. People are looking for answers to the issues. A very basic question: is hatchery or poultry an agriculture income or an industrial undertaking? A simple question. So I'm not looking at various circulars, statutes, and judgments. I'm looking for an answer. And because I'm not getting the answers, I am basically going and clicking the judgments, opening the judgments, and trying to infer the answers myself. Quality information, of course, comes from a robust database and a very efficient search technology. AI today is enhancing the way we could use data to get answers to the issues that people have. Lexlegis.ai is shaping the future of legal research by providing definite solutions to these complex problems. Just a brief background. That's my father in the back end, and that's me. He was the retired Chief Commissioner and Vice Chairman Settlement Commission. And I, together, we started building the largest corpora of judgments with shepherdized content. All right, let me explain you what shepherdized is. So shepherdized is a unique word where issues are arranged in a hierarchical fashion depending on what the latest status of that issue is. That unique arrangement, we are the largest, so we provide this to the government and other places. Lexlegis is a specifically custom trained on extensive in-house database of judgments and other legal documents. It gives you concise and meaningful answers in seconds. We are just not legal research. We are working towards becoming an entire end-to-end practice management system for lawyers and chartered accountants. So we started in 1998. We launched a search engine based off gist of decisions related to income tax and light taxes. In those times, there was a 1.44 MB floppy drives and CD drives. We used to provide it to the income tax department, various government offices, and the courts. In 2004, we started working on developing the largest database of judgments in India. In 2014, I was fortunate to be heading the central CDPC, the central of the National Judicial Reference System. It has got reference on Wikipedia. We built the largest repository of judgments and appeals in the country at that point of time. And in 2023, we started working on Lexlegis.ai. Just a short slide to tell you what Lexlegis.ai is in terms of data. We have trained it on over 10 million documents, which is equivalent to about 20 billion tokens of in-house, 20 billion tokens of data. Just to give you a comparison, one of the world's largest and the most valuable legal companies train on over 10 billion tokens worth of data. And we have fine-tuned on various foundation models, and we get very different results on very different models. The prompt changes, the output changes, and it has been a tough 1 year working on trying to understand for which use case, which model, which court, what kind of sequence of events that you need to do. Of course, that you know that data is key to a great LLM. It's garbage in and garbage out. Like I told you that we also worked on the largest repository of appeals. But for this, we cannot train it or use the appeal data, because when you use the appeal data, it is actually you are telling to the court your viewpoint, which may not be correct. So we cannot use that data to give answers for legal questions. So we have to use legal statutes, the circulars, notifications, or the cases. We cannot even use the commentaries, mind you. There are various commentaries available in the market written by very prominent authors, lawyers, judges. So one very interesting incident that I like to tell you is that there was a very famous, I'll not name him here, but there was a very famous lawyer who had written a commentary which possibly the entire country used to follow. And in one of the hearing, in one of the high courts, he started arguing something which was absolutely opposite to what he had written. And the judge intervened and told him, Nani, maybe you get the name, we have been reading your book and following you. And we understand that you have written this in the book, but what you are speaking today is absolutely opposite to what you have written in the book. So he replies, we get wiser by the day. So what it meant? It meant he had some idea of law. He wrote a book. It was a bestseller. People started following it. But when he got into more in depth, he changed his opinion on that issue. So we cannot follow commentaries. So we have to go by the line of statutes, of circulars, notifications, and cases. And so we are trained on only authentic data. So just a brief on what approaches have worked for us and have not worked for us. Of course, when we started, we all jumped at the possibility of RAG last year. And we said, RAG is going to be damn good. Let's do it. We started doing it. We showed it to a few law firms, and they said it was rubbish. All right? What were the limitations? Of course, the data quality. Second was the context understanding. A very simple five-word question. It may understand because it's using a semantic or keyword search to get some output, and then you give the results out. But context understanding, not very good. What if there are contradictory information in multiple documents? RAG is not good. It does not mitigate bias information. It tends to give biased outputs. It is not explainable. So if you would know that IBM had coined this word called explainable AI, XAI. So in law, the most important thing is trust. And because we are migrating from a different era to a new era, you need to give this explanation to people as to why this is being given as an output. So RAGs, of course, aren't good at that. Their temporal relevance, that is not there. Complex queries, if I'm writing a paragraph of my query, again, RAG fails there. We tried fine-tuning, and we saw of course, the first we tried was ChatGPT. The outputs were different. I would not want to say good or bad. It was different. We did some RAG, sent some data to ChatGPT, didn't work. We tried to do an Anthropic. We tried various models. And it just did not work. And we kept fine-tuning, etc. On some questions it worked. On some questions it did not work. On certain, say for drafting, certain models were good, but certain models were not good. So it was a large experiment that in case you're doing anything here, you will need to keep iterating and not be rigid on one output. And have a large research team to test that out. Because I personally feel on three segments or sectors, you need to be very sure of what you do before you launch in the market. So one is the finance sector. You cannot go wrong, right? Second is the medical sector. And third is the legal sector. Lives depend on almost all the three of them. Then we, of course, tried the network analysis. That worked a little better. That is to identify elements in a hierarchical network structure and then give it to for better inference. And so the basic questions is which model. If you're working on it, you need to work on multiple models and see what works for you. There's really no clear answer to that, and we are still exploring on various models while we have now launched it to a few hundred people, not publicly launched it to everybody, but we're learning a lot from the feedback from some of the largest law firms and consulting firms in India. So we tried, so after we did about a year's work, we tried it on ChatGPT 4.0, we tried it on HiQ, Sonnet, etc. And what our custom trained model, we found the outputs of that. Our outputs were maybe 95% plus preferred to other outputs. I'd like to also give you this information that there is a company called Harvey, a very nice company, large company, a global friend or competitor, if I may say. OpenAI has invested in the company. Of course, Sequoia, Elad, Kleiner Perkins, etc. have invested. But last month, even Google Ventures invested in the company. So this two investments from OpenAI and Google Ventures in the same company. OpenAI is almost Microsoft now, and Google Ventures is Google. This was something very unique. Both have their own models. Why have they invested in a legal company? See, these companies are extremely large. In the pyramid section, they are at the bottom doing very large solutions. They're not getting at the application level. They will want to get into application level. So when you're looking at the AI solutions, trying to build model solutions, there's so much opportunity. We are in 1998 of e-commerce. If this is e-commerce, we're in 1998. There's so much to do for everybody. Possibly some of us would retire. Me, maybe. It would still be evolving. And very clearly, I can say that we are 1% of what's going to happen in the future. All right? So please remember there are 3 layers. The one is the broader base layer. These large companies are solving the models, etc. Then there are the API levels, which you could do. And then there's the application levels. Remember that consumers will always use this application. Even if you see ChatGPT or the Anthropic interface, etc., those are the application layers that you're seeing, right? So I increasingly encourage young people to please think about users. Don't think of AI as the end, all right? These are the means to find some solution for somebody, right? These are the means to solve a problem. And you have to ultimately try to see how you can reach to the application. If you want to talk to the consumers, if you're talking to the large businesses, you could be in the middle layer. But please, I see a lot of youngsters solving something very basic, maybe using a rag coming out in the market that I'm doing this, and not exactly thinking of the use case. It's very important. Please remember, AI is not the end. AI is an enabler to help you achieve something that you were doing before and helping you do it faster and better. So there are various complexities in law, and this is something very interesting that you would like to know. So how many people here have never gone to the court for any dispute? Yeah, please. आप लोग सबको मेरा प्रणाम. All right. How many people who have gone to the court? Please. The number should add up. It doesn't add up in all audience, I know. I don't know why. Okay. So people who didn't go to the court, their hands were up faster. And the people who have gone to the court, they were more or less slow. So there are various, so when you're researching on legal, there are court hierarchies, right? And in AI terms, I'll try to speak a bit, maybe you all will understand. So for example, if there are 100 documents, 100 orders at the tribunal level, which says holding this bottle over my head is illegal, all right? Traditionally, what will happen is that it would be taken by a lot of the RAG models and other models that, this is the law. Now, there is one circular somewhere which clarifies that holding the bottle up till the waist is allowed. So, this becomes the law. And there are 100 documents which says that this is illegal. But this one document, which is a circular possibly, which is missing in my repository or which I have not trained, it says that up till the waist level is allowed. So one Supreme Court decision could overrule all, right? Then there are jurisdictional courts. For example, we are Bengaluru, so for a Mysore person, the Karnataka High Court would be the jurisdictional court. So that would be binding on him. The Calcutta High Court or the Bombay High Court would be a reference court. It would not be binding on him. So when you're searching, it's important to know where the user is asking the question and for which geography is he asking the question for. So you see, it becomes more difficult. It's just not a simple question in and question out. Then there is a document hierarchy. Statutes have more weightage. Statutes, like acts, have more weightage, bold, underline, sometimes, than regulations. And regulations may sometime overrule the statute because that's a clarification to the statute. And then there could be a case which could overrule it, and then a new act comes which overrules the case. So, it's complex. Then the period of query. You have been driving a car in a compound, in a private compound, and you hit somebody, you hit somebody on a cycle. Don't hit, but supposing you hit. This case happened in 2012. It's gone to the Supreme Court now in 2024. There's a judgment in 2023 which says that private silly cases, for example, is not supposed to be got to the Supreme Court. Very interesting. But this is not retrospective in nature. That means this is from 2023 onwards. Then can I show this to the user as an answer? No. What if this is retrospective in nature? That means it has started from some years behind, from 2020 maybe. But your case was a 2012 case, for example. So again, so this date is becomes such a fine point for getting the answers right to the users. It's not about just giving any answers. Then contradictory, overruled, superseded, not good law information. So all of these are, so temporal hierarchy, how has the law evolved over time? You know, for the example, like I gave in the starting, hatchery, whether it's an industrial undertaking or an agriculture undertaking. So how it was first an agriculture undertaking. You may have heard of the brands called Venki's. You know, Venkateshwara hatchery's got a brand called Venki's. There's a DJ hatchery. So they were not paying taxes in the earlier days. हम तो मुर्गी बेचते हैं, agriculture income है. Somebody went there and they saw they had Mercedes cars and they had this and that. And what kind of agriculture income is this? All right. And then there was a law formed. So law evolved over time. Then retrospective amendments, I told you. Frequency of changes, it can happen. I mean, GST is a classic example. Changes sometimes happens 2 times a week. And the accuracy itself are complexities in law. Complexity from the user's point of view. And this is one thing I would request all of you to please concentrate. I see a lot of, because we also run a small fund to help people who want to jump into AI, which is going to help our objective. A lot of people are not understand. They say that we have created a prompt. We have created a prompt, and users will write the prompt. Please understand that, with due respect to large companies like Google, everybody has been Googlified. Hatchery, industrial, weather, income, you know, it could be in any sequence and Google would give you results. But the LLM models don't work like this. Better your English, better the language formation, better the output. So first concentrate on the prompting, because users are not able to write proper question. They're not able to query properly. Then please understand that Rome was not built in a day, right? Neither the evolution happened overnight. People will not switch from traditional to just this output in one single day. You cannot stop the traditional way of doing things and say that shift to this. You have to give both the options to users, because users will take time. They'll mentally have to evolve and adjust to that. Then, you know, uploading of documents. Many people, are trying to solve the problem of that people internally have a lot of documents. How do they infer outputs on those documents? Because those are their private collections. And then the question comes whether it can be uploaded onto our server. Cambridge Analytica happened. Can it happen in my company? Can it happen in somebody else's company? So some people say that we delete the document, but we keep the inference or the vector embeddings. So is the vector embeddings not knowledge by itself? So an example where a senior person threw a flower vase on a driver to catch it and keep it on the table. He wrote an email to his lawyer, I threw a flower vase, but he missed it, hit his head and died, and he died, it's not my fault. It's admission of guilt. Will that lawyer put this on the web? How are you planning to protect it? Professional ethics, contractual agreements, client reputation. So we are, of course, solving for hallucination, explainable AI, and source references. Those people who are not seeing me, I'm seeing a timer run here, so I'm just speed it up. So we're focusing on quick data, accurate, bias-free, comprehensive, and secure. We're launching 3 models. Ask, that is a legal research model. Interact is a document summarization. And cross-document questioning. Interesting, because I file a case, somebody give me a reply, I file a rejoinder or a reply back to the reply, I get a reply back. Now the second reply and the first reply, those are 100 pages of document, but what is different in both the documents? What did Mr. Shetty say here that he's contradicting his own statement in document number 1? That's the use case. How do you solve that? And of course, drafting is the most use case that's going to be there. So, बंद कर दीजिए उसको, ऊपर वाली चीज को. Close that. Yeah, 1 minute extra for me, please. So you have a direct tax model. So in Interact, you have various. You have a summarize feature, you have a compare feature, like I told you. You have a review feature where you could tell you mentioned clause 5.14, but 5.14 is missing. You mentioned 1.5% incentive, but it's missing. You are going to Germany, but there's no GDPR clause. So those are the things like you would want to have, a lawyer would want to have. Of course, translate, etc. is very simple, but we have noticed that certain models, translations are better than simple machine translations that are happening. And of course, drafting, we are launching Scratch and drafting from templates. We're launching over 2,000 templates for people to start drafting. We are first launching for law firms, corporate legal departments, court tribunals, and later, next year, we intend to launch for SME, professionals, and with vernacular support. District courts are all vernacular. All right? And the sad part is that they don't have libraries, etc. They need this the most. So this is our go-to-market. We'll be live. We are already live. By next year, we should be in the US, launching the US models, etc., UK, US, etc. So we have shown it to a lot of senior people. They have all appreciated it. Nothing here. I've spoke to you about Harvey. Casetext is another example of a work well done, which was acquired by Thomson Reuters. So people who are looking at building models and thinking that, I want to sell it off to somebody, maybe including us. Great use cases in the legal thing. So this small team, Vishruth, who is a solution architect and alumnus of Vanderbilt, our AI expert, Mr. Praveen Sood, who was head of Tata Steel taxation and investor relationship is there. Mr. Raj Kapadia, who was head of litigations, he's there. And yeah, that's it.